Hello, everyone. Good morning. Welcome to another session of our first online Wills Week. Thanks to an amazing group of volunteer lawyers, this year Wills Week brings you 10 presentations, each unique to inspire and guide you in proper preparation of your estate plans. These plans include not only a will to protect your family, your business, and your assets, but also 2 additional documents to help you during your lifetime if you are ever temporarily or permanently unable to be as independent as you like to be. Understanding the hardships and additional costs that occur when these estate documents are not in place correctly will help you appreciate the value of getting professional help for you and your loved ones. Edmonton Community Foundation is pleased to provide this Wills Week resource for Alberta-based will and estate information. It dovetails nicely with our usual role as a trusted resource for how organizations large and small enhance our lives here in Edmonton, and how to create gifts that reveal your values in a way that fits for you. For this session, we are very fortunate to welcome Patty Coe from Bishop MacKenzie. Patty graduated in 2003 with a Bachelor of Commerce from the University of Alberta and with her LLB, Bachelor's of Law degree, from the University of Alberta in 2006. She was then called to the Alberta Bar in 2007 and is currently a member of the Law Society of Alberta and a member of the Canadian Bar Association. Patty is an associate with Bishop MacKenzie, and her practice area includes wills and estates, trusts and wealth management, and civil litigation. With an undergrad degree in commerce and accounting, Patty brings an understanding of business practices and operating challenges to her work. A devoted animal lover, Patty supports various animal welfare organizations, is fluent in Cantonese, plays classical piano, practices yoga, and enjoys traveling and eating. Take it away, Patty.
Thank you, Matt. Thank you, everyone, for joining us here today. And so, as Matt has indicated, and as everyone can see, we're talking about estate planning for blended families. Now, before we start, you'll see the PowerPoint presentation here. What you should keep in mind, everyone, is that what we're presenting today, the information that we're giving you today, is precisely that. It's information. It's legal information, but it is not meant to be legal advice, and it doesn't replace the legal advice that you may get from legal counsel. So I do strongly encourage everyone that if they want to go further in depth in estate planning, that they should consider getting some legal counsel and getting some very specific legal advice that will be catered to and will fit your particular situation, rather than the broad general strokes that you will be hearing today. What we're hoping to do in today's session is I'm hoping to give you some information about general estate planning, so you have a good basics on that, as well as touch on some topics or considerations that are very specific or maybe unique to blended families that we see today. And what you should be doing is walking away from this session with more questions than answers. It's meant to give you some things to think about, things that you need to take home to your family, sit at a kitchen table and talk about, think about, and then, you know, when you're ready to do your will or do some estate planning with your advisor, you will go in with a good background, with some good basics, so you know how to give the right information, ask the right questions, and have given some thought as to some of the unique challenges that you may be facing in your own family situation. So and another thing you should keep in mind too is what I'm talking about today is unique to the province of Alberta. So each of the provinces in Canada have different laws when it comes to wills, estates, how, you know, family members, family legislation, things like that are dealt with. And certainly outside of the country of Canada, in the United States, if you're talking about European, all of those laws can be different. So if you do have assets outside of Alberta, I strongly suggest that you also seek some counsel and advice from practitioners who are practicing specifically in those countries. Okay. So we can get started. Matt, can we go to the third slide, estate planning basics? All right, so I'll start off with giving you some, exactly what it says here, estate planning basics, give you some background as to what estate planning considerations are that apply to everybody, so that when we talk about some of the specific considerations in blended families, you'll have a good background on it. Now, first of all, we're talking about wills here. I think that's what everybody, when it comes to mind when you're talking about estate planning, wills is what comes to mind. A will comes upon into effect upon your death. So you make a will prior to yourself passing, obviously, while you still have capacity, but that will doesn't have any effect until you die. And what that means is while you are alive and have capacity, you can make new wills and change your will as many times as you want. What a will generally does is it appoints an executor, and it sets out how you want your assets to be distributed, and your executor will then go and carry out those wishes that you set out in your will. Now, there are two other documents that I will mention. It's not the focus of our seminar today, but you should also be aware of the power of attorney document and the personal directive document. These are documents that deal with you and your person and your financial matters while you are alive, but may not have the capacity to deal with it yourself. So the power of attorney document appoints an attorney to deal with your financial matters while you are alive. And a personal directive will appoint an agent to deal with personal matters while you are alive, but not necessarily have capacity. So personal matters are essentially anything that's not financial or asset-based, anything from where you live, your healthcare decisions, what you wear that day, whether you go to school, whether you have a job, anything that you make decisions about your person that is not financial in nature is dealt with in a personal directive. Now, again, not our focus of the discussion today, but these two documents, I would say, are just as important as your will and when it comes to your estate planning, because obviously it affects you while you were alive. And so I would also, while you are doing your estate planning for the purposes of a will, for how things pan out after you pass away, also give some thought as to what happens while you were alive. And the power of attorney documents and the personal directive documents are very large parts of that. So if we can go to the next slide, Matt. So if we bring it back to the will, to estate planning, why we're all here, why make a will? I strongly encourage everyone to consider making a will now. It doesn't matter if you're 20 years old, still in school, you don't think you have any assets, or you're 80 years old and perhaps you thought maybe you've dealt with a certain amount of things and you don't need to make a will. I think making a will now while you have the capacity I would strongly encourage it. And the reasons for that is, A, you actually may have more assets and more things to deal with than you think you do. We think of our assets as the house we own, the money that's in our bank account, and the car that we drive, right? But there can be many more elements to that you may not have given much thought to. There are pension plans, you have RSPs, the jewelry that you wear, maybe you want to gift it to someone specific. There are digital assets nowadays, anything from bank accounts that only have, you only access it through the internet, to, I've heard stories where, a very young 20-year-old unfortunately passes away and their mom finds out that, those online games that they're playing, that they've played for years and years and spent countless hours and resources, creating avatars or what they have in those games can be worth hundreds of thousands of dollars. It actually can be sold. So you may not think you have assets, or you may not think you have things to deal with, but you probably do. Other reasons to make a will: you want to have some say in, obviously, how your assets are distributed. Our legislation in Alberta, we do have legislation that covers situations where if you die without a will, the legislation does have a certain scheme as to how your assets will be distributed, absent a will telling them how it will be distributed. And it usually goes along the lines of traditional thinking, I would say. So if you have a spouse, everything goes to your spouse, and then your kids. And if you don't have those, it goes up the line to your parents. And again, depending on what your family structure is like. But that's something that's set according to either traditional ways of looking at things, or how the vast majority have done it in the past. It doesn't necessarily speak to your specific situation. So if you want to have some say as to how your assets are dealt with and distributed, then consider making a will, and sooner rather than later. You also want to provide for the people around you, your loved ones, so both in monetary terms and perhaps in other ways as well, which will become more evident as we talk a little bit more about some of the considerations today. Having a will also helps you manage potential conflicts or problems within your family or your loved ones. A will is, after all, a document. It's a roadmap to what you were thinking. And by actively estate planning and putting together a will, what you will be doing is also identifying potential conflicts or problems as you go along. So you may be able to address some of the potential conflicts that you see in your will or through your estate planning, and then perhaps it will not be a problem after you pass away. There are, of course, tax considerations as well, and we'll touch on that a little more in depth a little bit further down, as well as you may want to leave a legacy, right? So you've spent your entire life accumulating certain assets or working towards something, and you want that to be reflected at some point. So if we go to the next slide. Now let's take a look at some of the common elements that you find in a will. Now this is not everything that you can put in a will. There are a lot more elements that you can put in, but some of the major parts that we usually think about, especially for the purposes of this when we're looking at the generalities. First element, an executor, also known as a personal representative in Alberta. This is the person that you appoint in your will, who will be responsible for administering your estate in accordance with the wishes that you are set out on in your will. It's a big job, and this executor can be a person, it can be a corporate entity. There are trust companies out there, the wealth branches of the banks is usually what they are known by, who take this on as their job, as part of their responsibilities. You can have one executor, you can have two executors, usually not more than three. You can have joint executors, you can have alternative executors. We actually, I know ECF, some of the coming sessions that we have, there's a specific session on how to pick the right executor for your situation. So I do strongly recommend that if you have some questions about who you want to be your executor. We'll also touch on that a little bit as well, because it does become one of the issues that may be unique to a blended family situation. Now, another common element you may find in wills is dealing with burial and funeral arrangements. So some, not all, people will want to express their wishes for these arrangements in their will. And some people go further and they make those arrangements. They may go with make arrangements beforehand, buy a package, so that everything's taken care of by the time they pass. But what you have to keep in mind is, while you can express all of your wishes in your will about burial arrangements, funerals, ultimately it's your executor who has the final say. So if for some reason whatever you express or whatever you have arranged for is not doable or not workable, your executor does have that final say and is ultimately the person who is responsible for making those arrangements. Next slide. Another common element that you will find in wills is people will express their wishes as to who the guardian of your minor children may be. And this, what we have to keep in mind is guardianship over minor children does have its own legal considerations and is ultimately can be up to court approval and legal approval. So just because you put it in your will doesn't mean it will necessarily happen. For example, the natural guardians of a child are usually their parents, right? Their biological parents. And so if you you pass away and your spouse is there, but you put in your wishes that you hope that guardian of the children will be the grandparents, that may not ultimately come to pass because obviously the natural guardian of that minor child will be the surviving parent. So keep things like that in mind. And of course, again, in a blended family situation, you know, there might be some considerations there and some discussions that you may have to have around that. Now, the topic that people usually focus on and jump right to when we're talking about estate planning are the beneficiaries and the bequests that you gift to your beneficiaries. So beneficiaries are simply either the individuals or the entity, like a charitable organization that you choose to, who are your heirs, what we commonly refer to as your heirs, who you gift certain assets or parts of your estate to. And those gifts, we call them bequests. Now, the bequests can be either specific or residual. A specific bequest is exactly that. You specifically point out an asset that you want to gift to that individual. It can be anything from, you know, I have a bank account here that has $10,000 in it. Approximately, I want that bank account to be gifted to my grandchild. Okay, it can be my jewelry. I have a collection of jewelry that, or family heirlooms that I would like to go to, you know, daughter A, grandchild B. Or a car, you know, maybe you are you have a beautiful collector's car. Your son works on it. You may want to gift it to your son. The other kind of gift that you can give is a residual gift. So what that is your estate, when your executor takes over and steps into the shoes of being an executor, what they will do is they will take all of your assets and pay off all of your liabilities. And then whatever is left over in your estate after all of that is done is what we call the residual, the leftover amount. And a residual gift to a beneficiary is in relation to whatever is left over. So it's not specific to a particular object. It is more whatever is left over, this is how I want you to give to these individuals or to these entities. So usually it's as simple as saying, whatever is left over with the residue of my estate, divided into as many parts as I have children, for example. And if you have 2 children at that time, that residual gift will be divided into 2, that residue will be divided into 2, and then each child gets 1 part. Okay, it could be as simple as that. Or you might have, you know, additional people in that, and depending again on what your situation is. So those are usually the biggest elements that people are thinking about when it comes to estate planning. But like I said before, you're certainly not restricted to this. Your own individual situation may dictate other clauses being put into your will, but those broad strokes, again, is what you're usually thinking of. Okay, so let's move on, I'm thinking, to blended families, the next slide here. So we all know that this traditional family structure is no longer the norm in the society that we live in today. So the concept of, from 50 years ago, where you have, man and woman get married at age 25 and they stay married to each other for the rest of their lives. They have 2 kids, and spaced 3 years apart, and that's the family structure that they're dealing with. I'm almost thinking that's more the exception to the norm now, but what we're looking at now today is a much more diverse and dynamic family situations. And so, we're looking at, we have first marriages, second marriages, third marriages. We have common law couples. We have, individuals who are in long-term relationships, but who may not actually live together. You may have children from different relationships at different points in time. You may be sharing access and custody to children from different relationships. Or like me, your children might have 4 legs and are really furry. Or you may be in a sandwich generation where you are looking at both caring for your children as well as some aging parents. And you may be looking at, grandparents playing a larger role in family structures these days. Are you caring for your parents? Or perhaps your parents, the grandparents, are helping you care for children, helping care for you. So these situations that we see are very blended. There's a lot more considerations just because the more people who are involved, the more situations that arise, right? So it can be a little bit more complex, and there's no one way to approach things. There's no right or wrong, but there's just some things that, there's unique needs that arise, and you try your best to plan accordingly. Go to the next slide. Whenever you have a blended family situation, frankly, whenever you have any kind of estate planning situation and you have a family and loved ones involved, my number one start is you have to understand your family, okay? You have to understand your family members. You have to understand your family dynamics. And the first step to that usually is, well, who are the members of your family? You identify that. And again, because we're no longer necessarily dealing with a traditional family structure where you have mom, dad, 2 kids, and here is the focus of that family. You may now have, look at it. You may have a current other half. You may have a current spouse, a current adult interdependent partner. So that's the formal term that we use for common law partners. We shorten it to APES. So if I start going APES, it's AIPS, a shortened form of adult interdependent partners, commonly known as common law partners. So you may have a current spouse, you may have a current APE, but you may also have a previous spouse or someone from a previous relationship. You may have children from a previous relationship. Your partner may have children from a previous relationship. Who are those family members? And then understanding the dynamics between those family members is what sets the stage for how you approach any kind of estate planning. When you write your will, you want to understand and look at it from the perspectives of different family members. And that's how you set and manage expectations. That's how you try to avoid potential conflicts. So, for example, something as simple as, you have 2 kids and the question of do they get along with each other should come up, right? It should pass through your mind because it will have effect on things like, well, if I treat one child differently in my will than the other one, if they are very close and have no issues with each other, that might not be a problem. But if you have 2 kids who have always butted heads and don't necessarily see things from your perspective or from the other child's perspective, or understand the relationship you have with your other child, that's something to keep in mind when you're drafting that will. Again, it may go into how it is that you distribute assets. You may go so far as to explaining in your will or explaining through some other document why you did things a certain way. Things get a little bit more, may get a little bit more complicated if, again, as other example, if you've had a first relationship and you have children from that first relationship, and then you have a second relationship. And so you have a new spouse. Let's say you got married, you have a new wife, and you have kids from that first relationship. Well, does your new spouse and your children know each other very well? Do they get along with each other, or do they just flat out dislike each other? Different things happen at different points in time. And so you may want to keep that in mind too, and you will want to keep that in mind actually when you're looking at your estate planning and going through the different elements of a will and your specific considerations. We've also, seen situations where, again, I'm a litigator, so I see a lot of these things in court. I see things from when they go wrong. But again, do the different people in your lives, the family members in your lives, actually know about each other? I've seen situations where you have someone who was, let's say, happily married for 30 years, and then for whatever reason, they get divorced. And they have grown children from a first marriage, and, they get divorced and they move on to a second relationship. Maybe they don't get married. Maybe they're in a common law relationship. But for whatever reason, that individual never tells his kids or his first spouse about this new relationship, even though it's a very significant relationship. And then suddenly he or she passes away and everybody finds out about it after the fact. It can create a lot of issues. So if you actively think about it beforehand, identify who it is that your family members are, identify the people that you want to provide for or address in your estate planning process. It might help you also identify the potential issues that you need to address right now, such as introducing this person into your lives, into other people's lives, so that they know that they exist and it doesn't come as a complete surprise to the rest of your family, when you pass, and sometimes unexpectedly, right? I strongly recommend that you should be planning together where you can. And you should be communicating with your family if you can. It creates you telling your family what you're doing and the reasons you're doing it actually diffuses a lot of potential misunderstanding down the road, especially, again, if you have family dynamics where not necessarily everyone are super close or talk all the time. It might be as simple as you may have kids living very far away from each other, in different countries, in different time zones. And you may have one child who lives close to you and everyone else lives elsewhere. The people who live elsewhere don't necessarily understand your relationship with, for example, your child here, or something as simple as, maybe you have a business and you run that business with these other with a child who lives here, for example. The kids who live far away and don't see you on an everyday basis and don't see how that business is run may not actually understand if in your will you say, I'm going to leave all my shares in this business to this child who's been running it with me for day in and day out for the last 20 years. So if you sit down together and at least have a discussion with your family as to why you've done things a certain way, it helps them understand where you're coming from. And then what it usually does is it actually helps diffuse potential issues down the road after you've passed, when you no longer can explain to them why it is that your will reads a certain way, why you left assets to kids a certain way. Or, even if, for example, you can leave a charitable donation. Maybe you leave something to a cause that you feel strongly in, and none of the people the family that you left behind actually knew about how strongly you felt about this organization. If you just had a conversation with them beforehand, saying, here is what I'm doing, this is why I'm doing it, I believe strongly in this cause, it alleviates a lot of potential issues down the road, a lot of potential questions down the road, and it helps your family understand. So even if we're not going so far as to, again, litigation, at least they won't see the same kind of stresses or question marks after you pass, and it helps alleviate some of those issues there. So next slide. Now, see right there, joint assets. When it comes to blended families, there are, of course, some specific considerations. Make sure, again, the overall is understand your family, talk to your family, and that's the starting point for everything. But there are some, things that you want to consider in the context of that and understand the consequences of certain things, certain assets. And this is the list that we're going down, which may inform you as to what you can do with certain assets, how you can deal with certain assets, which again may help you look at your different family members and say, okay, well, what do we do with that? Now, again, this is not an exhaustive list. There are many, many considerations, and depending on your particular situation, some are very unique to you as well. But I thought I would just pull out a few considerations for the purposes of today's seminar, so that again you walk away with some more things to think about. Joint assets, okay? Joint assets are usually what you look at as your house, some bank accounts. You have two names on it. And there's different kinds of ways that you hold things jointly. So in a house situation, so anything that we consider real property, and you have what Larry was indicating, when you have land titles involved, you can hold an asset either as joint tenants or tenants in common. And usually when people think about joint assets, they're thinking as joint tenants. So what joint tenancy is you have an asset, let's say the house, that's held in two names, okay? Usually husband and wife. And when, let's say, husband passes away first, if your house is held in joint tenancy, that asset, by way of survivorship, gets transferred to the remaining owner, so the wife in this situation. So joint tenancy has the title, your interest in that title, transfer over to the surviving tenants, the surviving owners. And tenants in common is also a type of way you can hold ownership, where your title is more divided, if we can call it that, so that if one person passes away, that person's interest is actually continues to be held by that person, and it's dealt with by their estate. It doesn't automatically transfer over to the surviving owner, okay? Now, how you hold assets does actually have a lot of intersection with what your will does, or what you can and cannot do with your will, or what the power of consequences of your will are. If your asset is held as joint tenancy, where by way of survivorship, that asset passes over to the surviving individual, the owner, that asset actually passes outside of your estate. It does not get dealt with in your will. So it doesn't form part of your estate, doesn't form part of your residue. That's something that you really need to keep in mind when you're planning, obviously, because if, for example, your house is held as a joint asset, in joint tenancy with your spouse, when you pass and your spouse is still alive, that house will just get transferred to your spouse. And it doesn't get dictated by the terms of your will. So if your will purports to, let's say, for example, you say, and the house I'm going to leave to my two kids, and you cut the spouse out of it, it doesn't actually work that way. Your will have no effect because that asset actually goes to your spouse. And again, these are generalizations. There's always little details and intricacies that if you ever got into litigation, for example, over it, there may be some details in it that change the ultimate outcome. But generally speaking, assets held as in joint tenancy will pass to the survivor, and assets that are held in as tenants in common doesn't actually get passed to the survivor, it just stays in your estate. So if you hold assets, let's say your house is held as tenants in common with someone else, when you pass, and let's say it's half-half, your half interest in that house is actually dealt with your estate. So in those circumstances, your will actually govern what happens with your interest in that particular asset, that house, for example. Now, what you also want to keep in mind too is joint assets don't necessarily, like most commonly we're thinking of joint assets that are held with a spouse or with a partner, right? But especially if as you're aging or as your parents are aging, or even with your kids, I'm seeing more and more assets being held jointly with children or with parents as well. There is some in our laws, there's some interesting laws dealing with joint assets that are held with adult children. Okay, so when it comes to assets that are held with spouses, it kind of just passes on. There's a presumption that you meant to pass it on to your spouse because that's what's natural, and there's very little contention about that usually. When it comes to assets that are held with children, adult children, so for example, if you have a house and let's say your spouse had passed away, or you don't have a spouse, and you have one adult child, and you go, okay, well, you know what, I'm going to, or maybe you have two adult children, I'm going to put my house jointly in with my child's name, okay, so that when I die, maybe I'll just pass on to that child. Well, there's actually a presumption in law when you hold an asset with a child, an adult child, the presumption is that you didn't actually mean to gift the child that surviving interest. That child, if it's challenged, will have to prove that your intention was actually to gift it to him. And the reason for that is it's to protect, I think, some of elder abuse situations, or just, you know, again, some people, as they get older, they will put assets jointly into names with children just for convenience purposes, right? So they may say, okay, well, I don't want to deal with it, so I'm going to have child A who lives here with me. I'm going to put my bank account, jointly with that child, so they can help me do banking. But in the back of that person's mind, that parent's mind, their intention isn't to say, I'm going to put my account jointly into the name of with this child, so I could give them the money afterwards. I think I just want to help me bank. That money is still mine, and then, you know, when I pass, I'm going to divide that money between the 4 kids that I have who may live further away and don't necessarily help me with the banking. And so it's that type of law aligns with that type of thinking to protect usually the more elderly situation where they may have put a joint asset for convenience purposes and not necessarily to gift that child that asset. So if you do have joint assets with either a parent or with an adult child, what you will want to think about is, do you plan to give that asset to that child? And if the answer is yes, then you will likely want to put something to that effect in a document somewhere, in your will, perhaps, just to make it clear so there's no misunderstanding and there's no miscommunication. Or again, in the context of these discussions that you have with your family, hopefully you can sit down and have communications with them to tell them, and I have put this asset jointly in the names with your brother because X, Y, Z, and my full intention is when I pass, I want him to have that asset, okay? So takeaway from that is joint assets, especially when it comes to houses, there's 2 types of ways you can hold them jointly. One which passes on by way of survivorship, and which then will mean that it passes outside of your estate and your will for the most part don't actually govern it. And two, the type that the tenants in common type situation where your interests can actually go to your estate and be dealt with by your will. If you have assets that are held jointly with adult children, and again, as joint tenants, or with a parent, you will want to maybe take a look at that to make your intentions clear as to whether you want that asset to go to that child at that time or not, okay? Now, there are also vehicles and instruments that you can designate a beneficiary, such as RSPs, RIFs, TFSAs, and, frankly, pension plans, life insurance policies that you see on there. What you have to remember is when you designate a beneficiary within the context of these types of instruments and vehicles, those things also fall outside of your estate. So if you have an RSP where you have a designated beneficiary, largely that designated beneficiary will just get the RSP, and that RSP, the funds in that never go to your estate and is never governed by your will. This again have consequences for when you think about a blended family situation. And frankly, for all family situations, if you understand the concept that it falls outside of your estate, you will think and plan accordingly, right? So, for example, let's say again you've had a previous relationship, and now you have two adult children from this previous relationship, and you're now in a new common law relationship, and you don't have any children yet from this. You look at your asset base and you go, oh, okay, well, I have some RSPs that are, $200,000, and I have assets that are $200,000 outside of the RSPs. How should I divide that up? Well, if you need to understand that the minute you put a designated beneficiary on your RSP, it goes to that designated beneficiary and no longer forms part of your estate. So let's say you go, okay, well, maybe I want to divide the assets up, all of my assets total, to, it should be fairly equal between, my two children and my current spouse. And so in your will, you say, okay, well, whatever residual monies, assets that I have, I'm going just divide into three parts and give one part to each of my children and one part to my current spouse. Okay. And then you go to your RSPs and go, oh, okay, well, I'll just put a designation in here, and I'll put my spouse in as the designated RSP. What you then have to understand is that, let's say, $200,000 RSP goes straight to your current spouse right now. And then the $200,000 that's left in your estate in other forms of assets, and I'm just rounded numbers, then gets divided three ways between your two children and your spouse. So if your intention was to divide all of those assets equally between all of them, that might not have the effect. You'll have to think about what falls within your estate and what falls outside of it, okay? Same thing when it comes to pension plans and life insurance policies. Now, pension plans, what you also have to be aware of is pension plans are, depending on the type of pension plan, right? There's different types of pension plans, but the different types of pension plans have different legislation governing it. And for example, if you're working for just a company, not the government or anything of that sort, they have a specific legislation which governs pension plans, which actually may create some interesting results for you depending on what that legislation is. As an example, pension plans, you can designate a beneficiary, but they also have what they call a pension partner. And if you have a pension partner, that can actually override, in certain circumstances, your designated beneficiary. So again, if you have a pension plan, and let's say you designated a child as your designated beneficiary, in your mind you think, well, that pension plan should go to that child. But if at the time of passing you have what they call a pension partner, and that's a spouse, and generally speaking, a common law partner. Again, there's different definitions and different legislation. But if you have a pension partner, that pension partner actually may become entitled to your pension plan and the benefits that flow from it rather than your designated beneficiary. So keep that in mind. Again, when you do some estate planning, if you have that particular asset, you will want to understand what the consequences that flow from it, some of the legislation that is behind it, so that when your will is drafted in a way that actually gives effect, and you do some estate planning, so it actually gives effect to the way you want everything to flow. Life insurance policies, same thing. You can have, you have designated beneficiaries there. Generally, it doesn't get overwritten by legislation. So if you do it properly, life insurance policies also flow outside of your estate and doesn't get dealt with by your will. And then the last thing to consider, and it's actually a pretty big one, taxes. Okay, everybody pays taxes, and you will pay taxes even when you die. And you generally pay taxes the same way that you would while you're alive. So your estate is liable for the same amount of the same type of taxes you would have to pay while you're alive. So if you die in 2020 and you earned income of $100,000 that year, your estate will ultimately have to file some income tax returns that say you had income of $100,000 and pay taxes on that. When you pass away, the thing that makes it most difficult for estates is that, unlike while you're alive, when you pass away, there is what we call, there's an automatic deemed disposition of all of your assets. So whether you actually sell off your assets or not, the CRA and the way the Income Tax Act works is that they will deem that you have sold off everything, and then you will pay taxes on that basis. So usually what happens is when someone passes away, and if they haven't done any kind of tax planning or estate planning beforehand, an estate will usually see a very large spike in taxes because of our progressive tax rates. So you will be automatically deemed to have sold off your house, sold off any income properties, sold off all your stocks, anything that could get capital gains. They will deem disposition of all of those, whether you have actually sold it off or not. So you will generally see a very large income spike and then a very large income tax spike. Now, if you do some estate planning and do some tax planning, you may be able to minimize that, or to at least manage it while you are still alive. One of the ways that you actually can deal with some taxes that you may know are coming, and there's, taxes are a way of life here in Canada, right? So you may not necessarily be able to avoid them. That's not the purpose, but you may be able to, even it out or understand its consequences so that you plan accordingly. Charitable donations, you can get tax credits much like you would when you're alive doing that. So that's something to consider as well when you're doing some of that tax planning while you're doing your estate planning. One more thing I wanted to just mention about taxes too is for things like RSPs, or for things that fall outside of your estate, if you have assets that like I said, the RSPs, if you designate a beneficiary, falls outside of your estate, be aware that your estate might actually still be liable for paying those taxes, even though that asset may have gone to someone else. So very specifically, again, to an RSP, if you have a $100,000 RSP and you designate the beneficiary as a child, and you have an estate that's worth $100,000, and you say, okay, you know what, I'm going to leave my estate in the will to my current spouse, for example. You think, oh, well, I have a $100,000 RSP to my child, $100,000 assets to my spouse is all equal. Well, with the way taxes work, the CRA will actually go after your estate first for the taxes. So what's ever payable for income taxes on that $100,000 RSP is technically payable by your estate. So the designated beneficiary on your RSP may get the $100,000 free and clear, and then your estate may have to, let's say, pay $20,000, $30,000 worth of taxes on that, depending on what your entire structure looks like. And it may be left with, the estate may be left being worth, let's say, $70,000. And so your spouse, for example, that you left your estate to in your will may only end up getting $70,000. So taxes are an important consideration when it comes to estate planning, and certainly when it comes to blended families, because you're dealing with and trying to balance quite a few of different interests. And so again, understanding what that situation is will help you, again, hopefully plan for what the outcome is. Now, next slide, we look at here some further things to consider and keep in mind that have impact on blended family situations. We're hoping this won't happen to you because, you know, after attending the session, everyone's going to go out there, get some estate advice, and get their wills in place. So intestacy laws, when you die without a will, there's different treatments for different situations. But again, we're hoping this doesn't apply to you, because you will have a will and you will not die without a will, and you'll not be left with an intestacy where the legislation that the Alberta government has put into place is what governs. But just to give you an example of how, if you don't have a will, how in blended family situations, depending on what the circumstances are, you may get different treatments for different people. If you pass away and you have a surviving spouse or a surviving ape, if you have like the more traditional type of structure where all the kids, all your descendants are from that one spouse, then under intestacy laws, your entire estate goes to your spouse, the surviving spouse or the surviving common law partner. However, if you are looking at a situation where most blended families are looking at, where your surviving partner right now is not actually the biological parent to all of your children, the intestacy laws will treat it differently. Generally, if it either goes to the surviving spouse, either 50% of your estate or $100,000, whichever is the higher number, depending on how much money you have left, or and then the rest goes to the children. So again, in a blended family situation, if you don't have a will, under intestacy laws, your surviving spouse is treated slightly different than under a situation where a traditional model where you've had one spouse and kids from just that one spouse. You also may have a situation where you have, you know, both a surviving spouse, let's say you're getting out, and this is where we're talking about, you know, continuation of proceedings related to previous relationships. So when you pass away, you may still be in the process of dealing with situations from your previous relationships, whether that be a marriage or a common law relationship. So what you need to remember is that whoever takes over your estate will have to continue dealing with those proceedings. If you have matrimonial property type proceedings, for example, if you were fresh out of, maybe not even fresh, I've seen divorce proceedings and I've seen matrimonial proceedings drag on for years and years and years. So you may have gotten divorced from a spouse, but you may not have dealt with your matrimonial property, and there's ongoing situations dealing with that, but you are now either married again or in a different relationship. Your estate still have to deal with those proceedings after you pass away. It just doesn't all automatically go away. You have to take that into consideration. Any interest that a previous spouse or a previous partner may have in property, your current estate has to deal with before it can move on to, let's say, it's part of these assets that you're trying to gift to your beneficiaries. So take that into account if you have previous relationships where you have not dealt with all of the issues that have arisen from it, okay? there are also, and it comes up quite a bit in my practice, is at some point your current common law partner may have to either establish a common law relationship, or someone comes forward and tries to establish a common law relationship. And common law relationships here in Alberta are generally defined as, you've had a relationship of interdependence, as functioning as a domestic unit, an economic unit for 3 or more years, or for some other shorter term if you have a child together. And so we actually see a lot of fights, unfortunately, where a party, for whatever reason, is trying to establish that they are a common law partner of the person who passed away. And again, in blended families, if we go back to the situation that we were thinking of, an example that we're thinking of before, some people, for example, you had a previous relationship with kids, family, you get out of that relationship and you go into a common law one, and for whatever reason you don't tell your family, your kids, your previous spouse, other people about this new common law relationship. You pass away. And then this individual who, for all intents and purposes, have been acting as your spouse, you have a life together, you have all your ties together, all of a sudden, in order to establish her rights or come forward and say, I have certain entitlements to your estate, isn't left in a position where they actually have to go through the whole rigor of establishing that they meet the criteria as a common law partner. And so you can imagine the situations that causes, and the anxiety and the issues that come up with it. Again, all the way to litigation. I've seen plenty of those come up in all sorts of contexts. So when you're doing this estate planning, again, consider that communication, considering having that conversation with different people. I know in certain situations, people tend or want to minimize because they're taking feelings of their current family members and loved ones into consideration, and they may want to minimize the impact that someone else, another loved one, a common law partner, or the extent of someone's relationship with them, to carefully maneuver between different people's feelings. Well, if not everyone knows about each other, it actually does end up causing more issues when you pass away, and again, you don't have that opportunity to kind of mitigate that impact. So consider that if you find yourself in situations like this, of being very transparent about the different relationships that you're in, so nobody finds themselves in an unwanted situation. And also, for your purposes, maybe you want to figure out whether you're actually in a common law relationship, and whether you should be providing for someone within your will or your estate planning. We have cases where we have two seniors, people who have worked all their lives. They've have very established families, adult children, very stable, happy families, and at some point later on in their lives, they get divorced. We actually have cases where they're snowbirds, these two individuals, let's say man, woman, elderly, not even elderly, just considered, many more years than the rest of us. And they go and, meet in Florida somewhere. The two of them meet in Florida. They have families back home. They've been divorced, but they meet in Florida. And so they decide, well, you know what, just not to rock the boat. We're not going to tell our families back home that, we've met someone here in Florida. So what they do is, for 6 months of the year, they go to Florida. They live together in a condo that they have in Florida. They're really happy in Florida. And then 6 months later, after the snow melts, they come back to Edmonton. And they live separate lives, right? They go back to their adult kids, their grandchildren, and they don't tell anybody that they actually live with someone in Florida for 6 months of a year, and have this brand new relationship. So none of their families back home actually know about this other person, and then they die. And we have cases coming out of there where there's fights about with the other partner who was left behind from with the Florida condo, actually had to come forward and establish themselves as common law partners. And there is precedence for that, where even if you're not living together for 12 months of a year, you can be a common law partner. So if you have situations where you have a long-term committed relationship, for your purposes, you may want to figure out whether this counts as a common law relationship, whether you should plan accordingly, who you should tell, how you should provide for the situation in wills and in your estate planning. And the last category here, we have what we call family maintenance and support claims in Alberta. And you will want to keep this in mind when you do this estate planning. And what a family and support claim is in our legislation, we allow certain categories of what we call family members. And it's a confusing term because it's very specific in this context. These family members, if you fall within this category, after a person dies, and if they feel they haven't been adequately provided for in their will, they will be able to make a claim for further support. And so these family member categories are a surviving spouse or a surviving ape, minor children, children who are over 18 but by virtue of a disability cannot provide for themselves, cannot earn a livelihood, children who are 18 to 22 who, because they're going to full-time school, cannot be discharged from their child's care or from their parents' care, and actually grandchildren. If you are a grandparent or a great-grandparent who have taken on being a parent to a grandchild, those grandchildren or those great-grandchildren can also become family members who can bring a claim against your estate if they feel that they have not been adequately provided for. So again, for the purposes of your estate planning, you will want to look at who all your family members are, get some legal advice as to if you're not sure, and figure out who are the people that may have a claim to your estate. And if they may have a claim to your estate, what you probably want to do is take active measures in your will to provide for them, right? So that you don't get into some litigation further down the road, and address it the best that you can. So I'm just looking at the time here. There, again, these are all generalizations, a lot of broad strokes, so you have some things to think about. But for time purposes, we obviously can't go into all of it in greater detail. There's all sorts of war stories, all sorts of fun details that we can go into, but hopefully that we've given you some things to think about, some things to consider in your family situation. General rule of thumb, review your will and estate plan every 5 years, or every time something major comes around. Marriage, death, birth, every time you have a new family member or a potential new family member come around. Review your will, review your estate plan, so that, if you don't need to change anything, great. But if you do need to change anything, then at least you've put your mind to it and there's time to do so. Okay.
And just before I wrap up, I want to say thanks very much to Patty for taking the time to present today. It's greatly appreciated that you would take some time, almost an hour and a half out of your day, to chat with us, and we really appreciate you being here. So thank you, Patty.
Thank you for having me, and like Matt said, feel free to reach out to me with some more questions, and I'll do my best to address them.
But take care, enjoy the rest of your day. Thanks very much, everybody.
Thank you, everyone.